everybody. My name is Oliver Westmoreland. I am an ISC registered level 3 immigration advisor and I am senior immigration lawyer with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so that you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is about spouse visas, partner visas and specifically extension applications. Probably you already know different types of partner visa: spouse, man and woman; civil partner, could be man and woman or same sex; unmarried partner, could be any type or any combination. There is a first grant of leave, could be actually entrance or in country, first grant of leave, which is for 30 months, 2.5 years. After that, if the migrant wants to continue with this project, they can apply for extension. This is mainly what I'm going to talk about. Just broadly contextualise, if everything is good and perfect, after 2 grants of spouse or partner leave after 5 years, the migrant might be able to apply for settlement. If things are not quite perfect, as is often the case in life, there isn't this 5-year route to settlement, there is a 10-year route to settlement. So there have to be 4 grants of leave. That's the broad context. Today we are talking about extension. You can't really understand extension unless you understand first grant. The required things for first grant of leave is, very importantly, that the relationship is genuine and subsisting. Now, we know what genuine means, or well, most of us do anyway. Subsisting is a special word that the Home Office use. It means ongoing, happening today. Genuine and subsisting, and you might have to prove it. Finance. The basic rule is that the earner or the earners are earning at least £29,000 gross per annum. It could be a bit complicated. In the case of extension, both parties can be earners. So the salary of both parties, both partners can be taken, added together. So if it's earnings and salary, probably the most common way must be 29,000 between the two of them. I mean, it could be just one of them or between the two of them. If the earnings are not enough, there are other options. The most well-known one is savings. If you are quite rich, you've got at least £88,500 in the bank, you can satisfy the financial requirements just with your savings. If you have got less than that, but you earn something, there is a mathematical calculation. You can combine earnings and savings. If you want to know the mathematical calculation, ask someone extremely clever like Mr. Shah. He'll be able to give you precise and detailed advice about that. One way and another, either in the first grant or indeed in extension, the financial requirement has to be satisfied, and it's the same. For the first grant and extension, the financial requirement is the same. Accommodation. Now, this could be, sounds simple, could be quite complicated sometimes. The law requires that accommodation is suitable. That means mostly that it's large enough or that it has enough rooms. Also that it's of a reasonable standard, but that issue doesn't come up so often. The rules require that the accommodation is big enough, rooms are big enough. The really good way of being absolutely sure and being able to prove to the best possible standard is to get a chartered surveyor, and they do what's called an overcrowding survey. It sounds rather complicated. They come around with a clipboard, they measure all the rooms and they say who's going to live there, how many people are going to live there, and so on and so forth. The reason for this technocracy is that the requirements of the Housing Act 1985 have to be met, that the rooms are big enough. Possible a room can be too small for 2 people to sleep in it. Possible. So accommodation has to be adequate, mostly big enough. And English language requirement, which can be satisfied in different ways. Can be satisfied with an English language test from a list carefully curated by the Home Office. It could be met by holding a UK degree, which we imagine that should be taught in English. could be met by having a non-UK degree taught in English and certified by an organisation called ECTIS. And the easy way, or the best way, this is what you should aim for, be a national of a majority English-speaking country as defined by the Home Office. Unfortunately, a lot of countries are not majority English-speaking countries, but should you be one of those, like you're an American or a Canadian or an Australian or a New Zealander or one of these special people, you don't have to worry about English language requirements. It is satisfied automatically. Now, this is one thing where there is a difference. First grant, or the English language, if you have an exam, if you pass an exam, if you satisfy the requirements on the basis of an exam, the exam must be A1 CEFR level. That's the first grant. Second grant, it gets a bit higher, A2. Let me mention something that goes slightly off beam. Because family applications are a sort of human rights type application, they have a human rights flavour. The rules are a bit more flexible than other things. Possible, an overstayer, someone whose visa ran out a while ago, can actually stay, well, can apply to stay in the UK on a family visa. Difficult, more difficult, but possible. These people, they don't have to satisfy the financial requirement or indeed the English language requirement. But most people don't apply in that way, but do know an overstayer potentially can apply for, it's not an extension, is it? It's something like a first grant, but the rules are softer, well, a lot softer for them, but the application is more difficult. Mr. Shaw, I've given a broad outline. Do you have any questions?
Yes, I do, and thank you so much for doing so. You've elaborated quite in detail about this extension for spouse visa and civil partner visa extensions.
Unmarried partner.
Unmarried partner as well, exactly.
Mustn't forget that.
Fantastic. As we know, the new financial requirement for £29,000 a year has come into effect.
That was about 5 or 6 months ago, Mr. Shah.
Exactly.
But new is a flexible term in this film.
Yes. If someone has come to the UK initially meeting the financial requirement of 18,600 required at that time, can they still base the extension on that requirement?
Yes.
Okay, perfect.
You have what's called a transitional arrangement.
Brilliant. Okay, and in terms of accommodation, so if the couple has already satisfied the accommodation requirement in the initial application, do they have to demonstrate again that they're still meeting that requirement?
Not unless they've grown much larger. No, I'm sorry, that's a joke. No, if it was truly satisfied with the first grant, it's going to be satisfied still, unless someone knocks down part of your house or something. But if it's satisfied, there's enough rooms are large enough, it should still be satisfied.
Great. And when people are doing extensions, sometimes they can make a mistake, or the rules may have changed and they didn't realize. If an application is refused for any reason, is there a right of appeal?
Yes, there is a right of appeal to the First Tier Immigration Tribunal, which is the tribunal that sits in the UK, in various parts of the United Kingdom.
Brilliant.
Interesting fact, in such an appeal, you could introduce new facts into the appeal that have come up since the decision that was made.
Wow, fantastic. Is that the case with the entry clearance as well?
Entry clearance, yes, right of appeal. Although entry clearance decision is made outside the UK, it will be dealt with by the tribunal in the UK.
Brilliant, fantastic. You explained about the English language requirement. One has to do A1 to start with, for extension usually A2. But if somebody has a better English and they just attempt a higher level, for example B1, can they use a higher level certificate to meet the low level requirement?
Well, they can. I'm sure it confuses the decision makers, but they certainly can, yes.
Okay.
The way that the rule is written, it doesn't mean you have to have A1, you've got A1 or better.
Sure. It's best to keep it simple and just do what's required.
I would, because these decision makers, they're busy people, they're under a lot of strain and pressure. You don't want to confuse them any more than they are already.
That's understandable. If someone's come to the UK, everything was fine with their entry clearance. However, before they extended the visa or at that sort of time, if they have any issues with the police or any problems with traffic police or anything else, any criminality element that may come into picture, can that have some sort of impact on the extension?
Yes, it would depend on the seriousness. It could do. If you're in that sort of situation, you want to take advice from a good lawyer, it could do. But it depends on the seriousness of the matter. Traffic police, maybe not such a problem. Fixed penalty notice is not a criminal matter, not a criminal punishment or sanction. But let's say you get a fine from a court, that would be. If you get thrown into prison, most definitely, it could be. Even if you have a caution, Home Office considers that to be a conviction, because if you receive a caution and you accept a caution, you admit that you've done something wrong. So it could have effect.
Wow, okay.
Best not to get into that kind of thing, really.
Exactly. And if you do, it's best to take advice. Regarding absences, someone who's come to the UK on a partner sort of visa, would you recommend them to spend most of their time in the UK, or it just doesn't matter if they travel a lot?
I wouldn't put it like you put it in the latter scenario. It's best to spend a lot of time in the UK. It's best to spend large majority of your time in the UK if that suits your life. If it doesn't, you might be in slight difficulties. Let's say in the first kind of view, you spent most of your time outside the UK with your partner. It looks a bit dodgy because you're not really making your life in the UK. I would try and avoid that if I were you. If you're the migrant, I would just try and spend a large majority of your time in the UK. It's not an absolute rule, but it's a good principle because it doesn't really look as though you're fitting into the scheme.
True.
You come to UK and then you leave again and you stay outside UK for months and months. It doesn't look good. You might have problems convincing the Home Office that you are a proper case for extension.
Great. Definitely makes sense what you said. Well, I would like to thank you for today's vlog.
It's my pleasure. I thoroughly enjoyed it.
Amazing. And we see you in the next one.
See you next time.